Welcome to American Education FM, everybody. I'm Dr. Sean Brooks.
Ladies and gentlemen, welcome. I've got a different one for you here. Certainly relevant, there's no doubt about that. And plenty of information in this particular conversation that you're about to hear. This individual is a father in Michigan, and they were put in touch with me through a mutual friend who you may be familiar with, Outcast, from the Dangerous Info podcast. And he reached out to me, Outcast did, and he said, I know this guy. He's got a lot to say. He's got a lot of experience in this particular avenue, specifically having to deal with custody battles. And even more specifically, of course, the law pertaining to all of that. And at the exact same time, the involvement of the school. So I'll simply say this, just to introduce this very quickly. There's a great deal of information that is shared in this particular conversation. He's a very knowledgeable individual. There's no doubt about that. Certainly pray for him and his children as well. And with that said, I'm just going to step aside here and you can hear it straight from his mouth. Because again, he has a great deal of knowledge on this subject, and saying that he's been through the ringer from a legal process is an understatement. So with that said, give this a listen, ladies and gentlemen, and I will catch you on Wednesday. Peace. Well, why don't you do this real quick, if you don't mind? And it doesn't have to be quick. You can take as long as you want. Go back to the very beginning of all of this and describe this situation. Again, from the very beginning, chronological order stuff, and then we can kind of get into some of the legalese aspects of what some of these options might be for you in the future here.
Okay, chronologically, just for like the school portion, right?
Sure, whatever you want.
Okay. So, I guess a little bit before the school would be the fact that I've been fighting for custody for my daughter. She's 6, she'll be soon 7 in June. And I have had to do a lot of legwork to try to get as much information about my daughter as possible because the mom simply suppresses it. Not only is the mom suppressing it, but because she's been court ordered as sole medical custody, what she's doing is she's taking that document, that first order that gives her that, and she's giving it to the school, she's giving it to the doctor, she's giving it to basically everyone that she encounters with my daughter, and using that to try to bar me from any information gathering or basically anything that I should have the right to access as my daughter's father. And it has created a huge uphill battle. Now, what I have came across and noticed, and I recommend this to every father that I come across in Michigan at least. So I'm pretty active on like Reddit, as well as a couple other groups where I talk to some of these dads, and I tell them, you need to keep this MCL, Michigan Code Library, which means that it's legislated and codified in the state of Michigan, at your disposal. Like, memorize this. And that particular MCL is MCL 722.30. This is so important. And just to kind of break that down a little bit, or what that does is there's the custodial parent, who is the parent that mainly has custody of the parent, or of the child. I'm so sorry. And what MCL 722.30 says, and it's so short that I'll read the entire thing. This comes from the Child Custody Act of 1970. Now, I will start off by saying that in the state of Michigan, the way that the friend of the court gains jurisdiction in the matter is by using MCL 722.230. And what that is the best interest factors, where the court alleges that they're using the best interest factors of the child. That's up for debate. That's not the point of today, but what MCL 722.30 says is it's access to records or information by the non-custodial parent. It's short and to the point. Notwithstanding any other provision of law, a parent shall not be denied access to records or information concerning his or her child because the parent is not the child's custodial parent, unless the parent is prohibited from having access to the records of or information by a protective order. As used in this section, records or information includes, but is not limited to, medical, dental, and school records, daycare provider records, and notification of meetings regarding the child's education. Now, this is so important to the point of when I reached out to the school back in, I want to say late November, they were giving a lot of barriers. I do a lot of my own legal work, so I kind of knew a lot of what to say. But they were transferring me over to the school's liaison officer, alleging that they were also the school's lawyer. He immediately transferred me right back to the administration staff, mainly the principal, and said, this guy, he knows too much. I'm not going to be able to talk to him. And he was just kind of doing like a gatekeeper. And I mean that in the sense of like, I came from a background of sales, and you always have the gatekeeper. The secretary answers the phone and says, no, they're not in right now. You're not going to be able to talk to them. And they were basically doing this to try to move me away. Well, I did not know about 722.30 at the time. So come January, when I found out about that, I literally dropped that to the principal when I was talking to her. And I said, you can't withhold this. You're trying to allege that there's a court order that she has this custody, which is fine. But this 722.30, which again is an excerpt from 1970, I said, this precludes you even being at the school. And I'm going to give you like maybe 2 hours before you're going to be contacted by my legal team. And we're just going to go from there. If I have to subpoena the information, then I will. Well, I'll tell you, right away, they gave me my access to her attendance. They gave me my access to a lot of the stuff. And I've actually used this same thing for her medical as well. So this is like a very hard-hitting, very important MCL to memorize. Again, it's 722.30. But what this allowed me to do is get into my daughter's school records and see that she was having upwards of about 50 absences. Now, I've been talking to the principal this last week, so this is an ongoing and current situation, but the principal's kind of trying to math this out. And I don't know if you've heard this before, Sean, but what she's telling me is that she is considering 2 half days to equal 1 full day. Now, that might make sense if she was coming in at the half day mark and trying to, again, math it out that way. But that's not even the case. First of all, in the case of Child Protective Services being alerted because they are a mandated reporter, once you get abscesses in the state of Michigan of over 15 of them, they're supposed to be reporting that to the state and seeing what is going on in this situation. Well, if the principal's taking those 2 half days to make a full day, she's trying to use that to back herself off from the responsibility of giving that to the state. Now, one thing that I noticed that was very concerning, though, is that the school is telling me, so the school starts at 9 o'clock in the morning. The school is telling me that they consider a half day absence if the child comes in after 9:20. So really, you're 20 minutes late to school, and they're saying that it's a half day absence. But so then that doesn't really make sense. If my daughter's late 2 times past that 20-minute mark, totaling 40 minutes, they're saying that's just 1 day of school that you're missing. No, that's not true. She was late to school 2 different days, and by 20 minutes, and now you're only counting it as 1 day. That's wrong. Now, it's concerning for me in this case because I just got it in an email as of Friday. So we're talking about 2 days, 3 days ago. And there's a lot of these. And I think just in what they provided to me, there were at least 10. Then I started getting into the doctor's notes because they didn't want to release that to me. That's when I had to drop this email, and I plan on kind of reading it a little bit. But just to set the stage here, they're telling me these absences, and I've been getting a hold of the school asking, I want the actual medical notes. I want to know what's going on. Because here the principal's telling me I've got a note from her doctor excusing her for the whole week of school because she was sick. Well, when I get the doctor note excused her for 3 days. which is typical if they're on antibiotics, because once they're on antibiotics for a limited time, usually 24 to 48 hours, they're clear and they're clear to go back to school. Because a lot of the schools now, if you have a fever, you must keep the child out of school for at least 24 hours to eliminate the cause of infection. So I'm speaking to the principal. I'm asking her to allow me to have these notes and, what's going on with them. And they're kind of just pointing the finger to everyone. I've noticed the school does it a lot. And I'm talking to Principal Dottie. She's telling me, oh, Miss Maggie has the notes, but then she has me talking to a Miss Tammy. And next thing you know, I get this email. It's 10:26 in the morning. I get one from the principal that says, hello. The medical absences were due to an illness. The doctor excused them that week. Thanks. I said, okay, are you still providing the notes from this year? She says, hi, I'm not sure what you're asking. Thanks. I said, sorry, I was under the impression that I was being provided the doctor notes from the school year, not just the latest occurrence. She said, hi, she had a dentist appointment, a fractured ankle, and an illness. You will have to get medical information from her doctors. We are unable to give you the doctor's notes unless you have joint medical custody in your custody agreement. Quite simply, obviously this is her stagnating the situation and telling me she's not going to provide it to me. The email she sent was at 11. So by 12:42, when it popped up, because for some reason I don't get the emails right away, 12:42, just before 1 o'clock, right? I sent an email and I said, hey, Dottie, I hate to be a burden. I'm going to link MCL 722.30, so there it is again, to this email, as well as an excerpt from the current court order. Please note that the legislation from 1970 alone allows any parent access to that information, but I will be kind enough to include the most recent language from the order. If you could please grant my request, I would appreciate it. I'm disappointed that, again, I've needed to provide this, because, again, this is the second time. The first time I used it just to gain access to the system to be able to monitor what's going on with my daughter and her ongoing studies and grades and, which whatever that comes with that. So then the excerpt, I included that. Pursuant to MCL 722.30, both parties will have full access to all of CMW's records or information, including but not limited to medical, dental, and school records, daycare provider records, and notification of meetings regarding the child's education. Now, take note again, this email that I sent out was at 12:42. 18 minutes to 1 o'clock. Before it was even 1 o'clock, I received an email from the principal dictating the doctor's note. That's where I saw that they had excused them for the 3 days that I had formerly said. So at 1:02, I sent them an email, because I also noticed that when the principal sent it to me, she sent it in a whole different brand new email thread. So I replied back to the original email thread and I said, I just received the doctor's note from February 18th. Are you sending each one individually? And she replied back 5 minutes later, yes, working on it. Now that was on Friday. I didn't get anything else from them. This week is spring break. So it's yet to really see what's going to happen in this situation and how it kind of unfolds. But they're really trying to gatekeep this situation. And one thing that's really also concerning to me, so my daughter, she goes to a school district that is Heartland Consolidated Schools. But the mother works for Huron Valley Schools. And I've noticed that when I've been talking to the school, the mother will email me through our communication app and start asking me different questions. Now, at the time, I had sent her a message asking about her medical information. And the reason being was because my daughter incurred 2 different broken bones within 8 months of apart. And my daughter's 6. So that was already concerning. Well, now, when I had sent that last message, it went without reply. The mother tends to not reply to a lot of my messages, which has been a big issue. So that message went without reply. Well, since then, I was talking to the school. I mean, this is within a couple of days. And I start getting messages, hey, what is it that you're looking for? I forget the specifics of what she was asking. And I said, Are you talking about the medical request that I sent to you? Because that's the information I'm trying to find out and gather from you. She said, no, about the school. So, well, this is weird because I'm literally on the other line with the principal. I'm like, why are you asking about the school? I was talking about the medical part. Oh, well, the superintendent reached out to me and asked me to ask you these questions so that I could report it back to them. Well, I had already been told that the superintendent was out for the remainder of that week and the entire next week. So there was no way whatsoever that this superintendent was reaching out to the mother because they just were not accessible. So it just leads me to believe that because the mother has access to that school system, that she's actually intercepting some of these messages and some of these replies. It also goes to show that when I reached out to the HR department had reached out to the mother and told her, hey, he's considering a FOIA request, which is a Freedom of Information Act, to figure out what's going on. Because if people don't know, you have access to get a lot of these records. Not to expound on it too much, but you can put in a request. A lot of the time it does come back redacted, but sometimes there's some information there that's left to uncover. And for me, and in my situation, it's important because of my daughter, but also at the same time, my sister has been having issues with her son out of nowhere, where one of the other staff members were talking about how they wanted to try to get Child Protective Services involved with my nephew. And it was for no reason. And my sister thought it was really odd until I said, you realize that Charlie's mother works for the same school district that your son goes to. And it's only the son that she's having the issues with because the other two children are homeschooled. So it was really odd until I kind of put that together and said, I think this is what it is. Now, this was just maybe 4 months ago, so I have not put in that records request. And I kind of waited a little bit because once I found out that the HR department, which I'm pretty sure they're not supposed to do, had reached out to the mother and told her that information, and then she gave that to us in court and told us that she was contacted by them, I kind of backed off for a little bit just to try to let the dust settle and see what would be uncovered. But that's something we're going to be pursuing here shortly. So I am hoping for something to come out of that. But when people hide something, there's usually a reason. People that are open and leave themselves vulnerable, it's for a reason that they are open because they have nothing to hide. So just a lot of these bits and pieces kind of just keep on coming together. And, the greatest thing that I've had was that MCL, and it's really helped me out. So that's basically where I'm at in the current situation, but we'll see how it unfolds.
That's overwhelming, man.
Yes, it is.
That is just overwhelming. Well, I'll tell you what, let me do this if you don't mind. I sent you, of course, yesterday, and again, to my audience, they know that I'm not a fan of artificial intelligence. However, one of the interesting things about X's artificial intelligence is it can narrow a person's options, basically. And it can even provide some information based on numerous articles that have been written and, give people an idea as to exactly maybe what direction they should go in, but it also answers a great deal of questions at the same time. Let me read part of this. And then I even asked it another question specifically related to schools and what schools can and cannot do regarding, the Family Educational Rights and Privacy Act, which is FERPA.
Mm-hmm.
But certainly in your case, again, there's a lot of shady things going on. And like you just said, they're hiding something. And I mean, you have a pretty good idea as to what that is. The question, of course, is what is behind that curtain? Is there more information behind that you're not being told, and certainly regarding your child, your child's mother. Anyway, here's what it said, and here's the question I asked. I said, what is your advice for a father in Michigan attempting to gain full custody of his 6-year-old daughter from the child's mother who is suspected of neglect? Again, just a, pretty straightforward question. Of course, right out of the gate, it says I'm not a lawyer. It says, but, quote, I can offer some general guidance based on how custody cases typically work in Michigan, especially for a father in your situation. The goal here is to focus on what's best for the daughter, or your daughter, while navigating the legal system effectively. Here's a step-by-step approach you might consider. It says, first, establish paternity if you haven't already. It says in Michigan, if you weren't married to the mother when your daughter was born, you're not automatically the legal father, even if your name is on the birth certificate, unless you've signed an affidavit or parentage or gotten a court order. It says without legal paternity, you can't file for custody. If this isn't squared away, it says file the affidavit with the mother's agreement or ask a court for a paternity determination. This is your foundation. So, with that aside for just a second before I keep reading, that's kind of my first question, is were you legally married to your daughter's mom?
So we were not legally married. No, we were not. Unfortunately, I had my daughter outside of wedlock. We were engaged. To be honest with you, that situation of her leaving and how we separated is still to this day almost a mystery. My daughter was just before 1 year old before the mother decided to just up and leave the house that my daughter came home from the hospital in where she was born. And it all happened very quickly. She left me for another man. I mean, we're to the point of, like I'm saying, we were engaged. I had paid $1,000 on a home inspection. We were going to buy a house. And I reached out to her one day, like during the day. I said, hey, do we need to go meet up with the real estate agent? She said, no, it will be okay. She had the other guy go and sign the house. And so by the time we got to court, and what ChatGPT or the AI is saying is very clear and important about the affidavit of parentage, is because when I went in there and I beat my chest like every man wants to do who's proud and loves his child, all they did was link me up to child support. And I don't mean to make the conversation about child support, but that's exactly what they'll do. If you go in there and you consent to their jurisdiction, what it's going to allow them to do is put you on the child support. Now they're going to give you custody or parenting time at some point or at some time. But what that's allowing them to do is give them that fiscal incentive to start taking some money, to start issuing income withholdings. But if that you have the affidavit of parentage, you can go in and start getting 50-50 custody. Now, I went like 18 months without ever even being able to see my daughter. I called the court. I called the police. I called every number that I could. And I was told the exact same thing. Sir, you have full rights of access to access your child. You can go see your child at any time. Well, what do you mean? The mom's not letting me see her. Oh, well, in that case, you're going to need to get an order from the court in order to visit or to have custody with your child. Well, now because 18 months went by and I went into the court, they said, this child no longer knows you. There's no bond. They don't know who you are because they were away from you so long. And granted their age, they're not going to remember something like that. So we actually started to go through supervised visitation. And not too long into the visitation, and it was a little unruly in there because of COVID. So there were like no toys. I was having to bring bags of toys. Well, on this specific situation, my daughter was a little apprehensive to going in, and she would sleep in my arms on the days that she would come in anyway, which I later was told the mom was waking her up early so that she would sleep during the visits. She would tell her she would feed her afterwards just so she'd be more irritable. And it makes sense because this person just seems like they would do that at this point. And I pray for them, but I hope that eventually it will work out. Well, anyways, I went to the doorway and I said, come on, sweetheart, Daddy's here to play with you. I have a doll for you and come over and play with me. The mom freaked out. And she said, I had called this facility earlier in the morning and I told them they were not to tell you that you're the dad. And she's not to know that you're the dad. Well, who is the child being told then that they're coming to see? This is my daughter. For what other reason would she be going to visit with some strange man? If that's really how she viewed me at the time and didn't know who I was, I don't know. Now, I asked the man, the third-party representative, who, oddly enough, we went to the same facility when I was younger and my parents were divorced, and they don't have great reviews, but we'll leave it at that. They need to remain unnamed. Well, he wouldn't document the situation. And when I said, well, I need it documented because she's screaming in the middle of the hallway, he had to escort her out and there's other families going on. He said, you know what I'm going to do about this? I'm going to end your guys' visits here. So they ended my visits, and I went and I created the court paperwork to go in and get back with the visitation, and I objected to the things that were going on. And I got a phone call. I was standing in my mother-in-law's kitchen looking out her window, and they said to me, I'm sorry, sir, but I pushed the wrong button. I rejected your paperwork. What I can do for you is re-precipate it. And for those that don't know, precipate means to take your motion. So you create your motion, which basically says how you want to move the court. And to precipate it means to put that motion on the docket so that the court will actually hear you on your motion. And he said, I can re-precipate it, but just keep in mind that if I do, it's still technically going to be outside the 21 days. And so it's probably going to be dismissed. And of course, that's exactly what happened, which then tied me on to an astronomical amount of money for my child support order. And it just linked me up to it. And had I had that affidavit of parentage, had they not kind of skated me when I went in there, it would have been a lot different. But it caused a lot of issues for me. And still in the current, it's caused a lot of issues. I've had a lot of strong words with the referee mainly, because you don't see the judge too much in family court, but you really have to know what to say and be well in the language, I guess, if you will, because they're not going to want to hear a lot of oral arguments. You're going to want to draft up your motion so precisely that your case will rest directly on that motion. If you're going to leave it open to oral arguments, you're going to lose every time because you don't know that the judge is going to allow you to speak.
God bless, dude. What a nightmare.
It's been crazy.
Yeah.
I read these stories or I tell people about them and they can't even believe it. So for instance, November 19th, 2019 was when my consent order was signed. But the way that day went was extremely strange. So they had already enacted a bit of child support in the child support order on me, even though they weren't letting me see my daughter. So I made sure that morning that a payment went through because I wasn't able to get in there and make a payment. And so I had called my friend in the parking lot and I said, I need you to make sure that you make this payment and that it shows that it's made and posted because I just had a weird feeling going on. I assume it had to have been from God because there's no way what I'm about to tell you could have happened the way that it did. I went in and I walked into the courtroom and no one was really in there. I seen the mom, but I didn't see anybody else. So I said, okay, I'm going to just go ahead and go use the restroom. So I kind of stepped out for a second, but I had went back in and I heard the prosecutor, who I later found out was the prosecutor. And he's bent over and he's talking to the mom and he goes, don't worry. What I'm about to do is going to be crazy. You're going to see something awesome. So I'm like, well, that's weird. So I go to the bathroom and I'm like, okay, I'm comfortable. I'm going to be able to handle this situation. You know, I'm praying. And I go to come out of the restroom and I turn the corner to the left and I see a whole group of police officers. And I'm like, oh, I know that they're here for me for sure. So I step back around the corner. I take a sip of water from the drinking fountain there. And I go, let's do this. So I come out around the corner and they're all there. And of course I get to stop, sir. You're being placed under arrest. And I simply walked right up to him and I said, I don't think so, guys. I've already made sure that I'm up to date on the support order. I knew that was your point, was to try to arrest me for trying to say that I was behind on this obligated amount. But you can actually call your supervisor and double check. They didn't even put their hands on me. They let me walk right through them. I had the piece of paper. I said, here it is right here. Go ahead and take a look. They said, thank you, sir, for your cooperation. I walked into the courtroom and the prosecutor's standing there and he goes, oh my goodness, you're in here? What was going on out there? I said, do you really want to try to play games like you didn't try to orchestrate this? I said, I knew it was you because I had listened to you when I first entered the courtroom and I heard what you were saying. I said, don't try to do that with me.
You should have
well,
looked. You should have looked at him and said, "I don't know, but you're going to see something that's really awesome right now."
yeah, no kidding. I should have gave him back his words. Oh my goodness, I couldn't even believe it. I really couldn't. At the same time, it was crazy too because my friend's wife was there. She came with me as a witness, and this same prosecutor in that same day. It may have been a subsequent one because they expected me to go to jail that day. But he told me, he goes, okay, the fastest way for you to see your daughter is to go ahead and sign this order. And I didn't really realize it as much because the way they had it written was that they were going to start giving me this custody. So I signed that consent order, and they immediately, that's when they had started putting us into the supervised visits. Because prior to that, I had nothing. That was at the end of 2019. My daughter was born in 2018. I went so long without seeing her, it just killed me. That was my first daughter that was ever born, and it just hurt. So I had a son before, but daughters are different. And if anyone has multiple children, they know they are individually so different as people, even as small little humans. They are so individually different. And I love them. I've got 5 children myself. And a lot of people say, why do you have so many kids? The economy's down. There's inflation. There's this and that. I said, I don't care. We're going to make it work however we make it work. You can invest your money into your house. You can invest your money into your car. But a lot of those things you're going to end up wanting to sell. You're going to move away from. You're not going to have forever. But your child, God willing, will be in your life until the day that you depart from this world. And for me, investing into them is just more fulfilling than anything else imaginable. And so it does suck, right? Like, I hate to use that word, but it does, because the pain and the suffering and the long suffering that you go through in these situations is so bad. Like, there's been times where I've wanted to just give up and say, maybe I just sign off on this. Like, this is just crazy. It's so much for me, but I just pray and I make it through, and it's fulfilling. Even the smallest, slightest step that I get, it's fulfilling. I mean, right now I'm finally at unsupervised visits. I mean, we're talking about, I've been fighting for years, but we've gone through 2 different parenting time places where the mother causes some sort of issue and they stop it. Or, okay, here's one, for instance, right? When she broke her, let's see, it would have had to have been the second fracture because it was later this last year. I had called and I said, Google, who I used also, the AI, had popped up, and I said, what do I do if my daughter has had 2 different fractures within 8 months? So they both happened, those bone breaks happened within 8 months. And Google AI said, obviously consult a doctor, check for bone density, because at that age, the children's bones are a lot more flexible. Like, they really shouldn't break. Like, unless there's a severe trauma to those bones, they're not going to break. Children usually, they bounce, and so they're usually okay. But then it went on to say, also, if your child has had multiple fractures within 8 months, you should contact Child Protective Services. So reluctantly, I did. And I'm not a big advocate of Child Protective Services because I've heard more stories of them not doing something in a situation where you would assume they would than otherwise. And you get a lot of horror stories about Child Protective Services as well. But I contacted them. The mother was obviously contacted by Child Protective Services, and she immediately called the parenting time place, who removed our visits. And I had to call the friend of the court specialist to have him call them and say, you guys are to continue with these visits. What is it you're stopping them for? Well, the reason they were stopping was because they called to question me on whether or not I had called Child Protective Services. And my response, although I don't remember exact words, was pretty simple. I said, you're the third party monitor for these visits. You guys do not go above and beyond that purview, that jurisdiction, essentially. I said, we come, we have our time here that I pay for, $60 an hour. And after that time, we do not talk to you unless it's to communicate and schedule when the next visit will be. I said, did you follow up with her doctors from the prior bone fracture 8 months prior? No, you did not. Have you checked to make sure that she was wearing her cast? Because the first one was on her wrist. The second one was on her ankle. No, you did not. When I would question you guys after the visits, did you ask the mom why she wasn't wearing the cast? You'd say, we don't ask that question. We don't do that. So what business is it of yours if Child Protective Services was called? Because that's a third-party, state-funded office that looks into these matters where you don't. And they got upset. I said, I will not answer your question. They even tried saying, I will give you one more opportunity to answer this question. If you lie, we will find out about it. But if you did, we just need to know and we'll go from there. No, it's not your business, and I will not be questioned. I'm secure in my rights. But they did. They canceled it. It was for about 3 days. No, I think it was even less than that. I think it was like 2 hours. And then eventually, like, I had spoke to the owner, Chandrika, and had said, what is this? Like, why is your person calling me saying this? And she tried to play it off. She never canceled your visits. I said, I have the email right here. Like, she literally emailed me afterwards to tell me that the visits were on hold and until further notice. And this was the reason why, was because I was calling to make sure that my daughter's okay from this person who is just having all these issues. I mean, I just don't understand it, how they're not taking this more of a critical situation, because she has multiple children and she's getting called on Child Protective Services for the other children as well. One of them is a young man. He's 4 years old. I'll leave his name out, but he has a condition where he cannot speak. He needs help to walk, and he went blue because he couldn't breathe. Now, I'm a former firefighter, and you don't go blue until you've lost oxygen to the brain for quite some time, usually about 2 minutes. So for that to happen, where was she? Why wasn't she watching him? When my daughter broke her wrist and she said, I fell, slipped on the deck, and it was the evening of Good Friday of this last year. You could literally look up the weather if you don't believe me. So I saw her in the morning of Good Friday, and then I saw her on the Saturday the next day afterwards. But she said that she went home, slipped on the deck, and laid there until somebody came and got her. Where was the mom? Where's the mom when she's getting dropped off late? Because on the same day that it shows my daughter is absent, the mom is on a hearing with me before the front of the court for a show cause action that I had to initiate. And the reason why I had to initiate that was because, again, neglecting the court order, we just got these unsupervised visits, and the court order stated for Saturday and Sunday, and she messaged me and said, clearly this is an error. I'm not letting you see her for 2 days in a row, and didn't show up. Even though I told her these actions are contemptible. Like, the court can sanction you, fine you, or even possibly impose a jail sentence. And you're not going to follow this court order. She was told by the police officer. She was told by the friend of the court specialist. And all her response was, I've informed them that I will not be following it. I couldn't believe it. So we'll be back on the 2nd. Unfortunately, I had to repress the pay the action, which is to put it back on the docket. And the reason why was because the referee tried to be involved in it. It wasn't even a hearing. It was a conference, and we'll just go from there. So I try not to get upset about it or frustrated. I understand you're at the mercy of the court, waiting for them. I'm looking a little more into trying to file, ex parte actions and see what we can do for there. Or even if she breaks another bone or something, it's going to be an emergency hearing, and hopefully we'll get it by that week. But I'm really hoping that's not going to happen. I really don't understand it either, because my daughter's not really a wild and crazy child that I would think would be falling. But, it's really upsetting. For the last couple of months, she's not been wearing her boot for her ankle. This last Saturday when she came over, not this last Saturday, but the Saturday before, she came over and we were at the beach by my house, and she had slipped a little bit on the sand, and she said, I slipped because of my ankle. It's been hurting. Now it's hurting really bad. It's been hurting for a lot lately. But she wasn't wearing her boot. Where's her cast again? Like the same thing as the wrist. And I don't understand. And I've tried. So I've used the 722.30. And the reason they had put it in the court order was because I went to the court and I said, I need access to these doctors. She said, well, he knows who the pediatrician is. He knows the doctors. I said, yeah, that's fine. And I can use the 722 to go to these doctors and have access to the information. But here's where the issue is. There are probably hundreds, if not thousands, of bone doctors in Michigan. For me to call each one's office and say, is my daughter a patient there? First of all, they're going to wonder, why doesn't this dad know where his daughter's a patient at? So that's already going to open some barriers for me. But number two, for me to try to call that many that's ridiculous for me to have to ask that. So even at this last conference, this last Wednesday, I went in and I said, and she still hasn't followed this part of the order. She's supposed to give me that information. It says it right here in subsection I. She's not done it. And the referee and her response, the mother's response was, he knows who the pediatrician is. I said, no. You know what we asked for. You know we were in front of the judge when we did it. Now we're in front of the referee. You can continue with this if you'd like, but we'll be back here in 2 weeks. So unfortunately, it's just, you got to have patience in these situations. It's really hard to do sometime, and I totally understand it. But sitting down and staying up really late after my children have gone to bed and studying this on how to set up motions, how to put your case captions on there for your case, to be able to submit paperwork, to be able to supplement with evidence if need be, to know what type of evidence, if it's like something exploitive, where like, you know, be an indecent photo, or maybe there's a bruise on your child that's near an indecent area. Those don't even get sent into the court file because of a whole different way that you would send it in, and you would have to actually contact that specific chambers to see how to do it. But learning all of this has been so beneficial for me, more so because I can understand what you're seeing on the news, and I'm not a big mainstream news person, but a lot of the stuff we see going on, I actually, so in Trump's first term, I used the same one that he used to submit to the clerk, and I can't remember it now off the top of my head. It's one of my, I shouldn't say it's one of my favorites because look, I can't remember it, but it was a United States code. It was like 15 US 1504, I think is what it is. And it basically states that if you hand the paperwork to the clerk and they destroy it or they alter it in any way, that is a huge charge that can be brought against them. And it was just kind of important to me because I was submitting paperwork to the Oakland County Court and they would dismiss it and they'd dismiss it and they'd dismiss it. So then I supplemented it with that US code, and next thing you know, the clerk started taking it. And it was just kind of eye-opening that they don't care about you, the individual. They don't care about little issues like family court and who's trying to see their children. What they care about is that money. They care about the support order. 2025 fiscal year incentive came out for the friend of the court for Michigan. It was like $1 million or $1 billion, something crazy like that. But the way that it all works together, it all came back from because of Social Security. When TANF, helping needy families first came out, and the reason why they started doing child support in the first place was because they saw that the state lended out $1 million that year, and they had to come up with a way to recoup the money. And the way they recoup it is by every dollar that the friend of the court in the state pulls from those fathers, the federal government reimburses the state. So I think in the state of Michigan, it's at 70 cents. So for every dollar they pull from you in support, the state of Michigan is going to get 70 cents. Now, this shouldn't be a legal ongoing thing because there's a court maxim that says that equity will not aid a volunteer, meaning the court should not be using its time in order to try to pull these mainly fathers in and get this money. They use a lot of resources and utilize a lot of taxpayer money as well as the money that they recoup back to do these things. And I know your podcast is mainly focused on schooling, but it's very eye-opening whether you're in the family court situation or not. Just look up how much revenue does your state child support gain every single year, and why is it gaining revenue? If that money's not just going from one parent to the other, then how is it gaining revenue? That doesn't make sense, right, in itself, because no one else should be getting that money except from parent to parent. But it's also another thing. If you came and you sued my company or me individually, everything would be audited. They'd ask for all this paperwork. Child support is the only thing that is not audited. The mothers do not have to show, and I say mothers just because it's mainly mothers, but they don't have to show what did they pay for diapers, what did they pay for these clothing, what did they pay for daycare. And that's an important one, too, because you see them submitting handwritten notes if they're asked, or they just say, I get them watched over here. It doesn't matter where they get watched. We'll go back to that MCL 722.30. You have the right to access those daycare records. Are those numbers that you're being provided in the front of the court that you have to pay, are they actually real? Because I can tell you in my situation, being charged as part of my structured order $410 a month in just daycare, but I go into the court and I say, she's 6 years old, she goes to school. When is she going through daycare? And the mother admits she doesn't go through daycare right now during the school year, only during the summertime. Well, then why is it still there? Why am I still paying for it? But the court didn't want to make a change and alter it. So you'd have to file a motion for that change to happen. But yet when I seek in my motion for my daughter to finally, and it was finally found favorable for it to happen, to seek individual counseling, the mother wants to say, well, he needs to pay for half of the medical expenses, which is actually 70% of the medical expenses. And the referee, although the motion we were there for was for custody and parenting time, wanted to change and alter that. I said, no. We're not altering the child support schedule right now unless you want to, for one, lower that daycare cost because it's not even happening or being fulfilled. And number two, you can change it to direct expenses, which is a legal sense of the term, means that whatever the dad is paying for, he doesn't ask the mother for money. Whatever the mother pays for, she's not to ask the father for money. And it kind of helps break down and audit it in a way for the child support to actually occur more effectively and equitably, because a lot of these times people are getting paid. I mean, wouldn't be the first time if I were to say there's someone out there who their career is having children, if you will, to say it nicely, but can't work, is getting paid $3,000 a month in just child support. Like it must be nice, it must be nice, but I pray for those people. I pray for these situations, and I hope that what I'm doing is making a difference, because it's in my opinion, who am I? But it's in my opinion that I believe that both parents are important in the child's life, and there should be more of a push for an equal time with that child as there is for this stretch for child support. And just unfortunately, we're not seeing that happen, but squeaky wheel gets the grease, right? If we stay loud and proud about it and make it make sense, can't get frustrated, can't get angry, because then that you're going to sound like a resounding drum. They're not going to want to hear that with love. If you're angry, you have to stay patient, and it's so important that you do. But we can make this turn. We can make this change and make these things happen. You might have to go through a lot of legwork and seek out these records and go to these different avenues, but eventually it will be so worth it. And I can tell you children just are. They just really are. So yeah, it's been crazy.
No kidding. Let me ask you this. So you weren't married. Does that mean then that you did sign the parentage documentation?
So I don't think that I did, actually. I don't think that I did. And the reason why is, kind of an odd one. So,
I mean, here's the reason I ask. Just very quickly, the reason I ask is only because, again, based on this answer that's been provided here, it would make sense on the end of the other individuals that you're working against to not give you information, because why would they? If they're not viewing you as being, I mean, you're the biological father, clearly, but legally speaking, you're not the parent of custody, so why would they need to give you that information?
Right. So sometimes it's a good defense if it's for child support or something like that. So I kind of started to gather that this person was going to be a little greedy. the reason I didn't sign it in the first place was because I had an issue with my son's mother, who I had before my daughter. And she had actually alleged a crime that did not happen. And I unfortunately lost my rights to my son. So, but that happened back in like 2014. So it was like 4 or 5 years beforehand. And the mother of my daughter actually came and testified how great of a father figure and spouse I was to a spouse to her, but a father figure to her daughter, who I raised for 3 years. And so at the time, I just kind of wanted to remain in the dark. I'm more of a not like a sovereign, but I try to remain pretty sovereign and apart from the state. So I didn't want to put my name on it. But a lot of that stems from, I may be getting my years wrong, but in about 1958 was when that $1 million relief came to those needy families. And what that created when they created the child support going on is it put every single father's name into a registry, and they were all marked as closed, like closed case. But as soon as you have a child and you sign the affidavit of parentage, now what I've been told, so this is alleged, you can look this up, but is that once you have a child, it flips you to an open case. And so they know that you're a father figure to this child, which then allows for them to take the child support should something occur. And because that happened, I didn't want to be on that registry, so I didn't sign it. I've actually tried asking for the biologics to be taken, for them to do a DNA test and actually prove it, because it's just a defense that I'm going to try to use here in the future. And the whole reason was because what happened was when my child support is marked at like $1,200 a month. It's pretty astronomical for a now 6-year-old, but it's been that way for years. And the reason they did it was because I was working a concrete job where I was just a laborer. It was $20 an hour. It wasn't a lot of money. So, I mean, it's like, how does it get to $1,200? Well, we were pouring concrete for a police station, and so that's prevailing wage. And for those that don't know, prevailing wage means if you're doing work for a county or a municipality, they'll pay you at a higher rate. So they were paying me at like $63 an hour. Well, I didn't do the concrete very long because I messed up my back, and I think I was there for maybe 3 months. But what they did was they took for that 3-month period and used the highest month of what my earnings were and put that as what I made across the board. And when I went into the court and I said, this isn't right, I was only there for 3 months. I don't make that kind of money. I wish I made $63 an hour. That would be great. But I don't. And so they set it so high, and it was a referee who was on her last week of hearings before she was made a judge. Never got to see Judge Saban again after that, but that was the situation that happened. And you know, I don't want to leave this pointer out to any of these dads that if they're listening and it could help them out. One of the greatest things that has also ever helped me, if you see these filing fees and you're like, how am I going to pay this? It's $100 just to file a motion. Like, that's crazy. And you don't even know that they're going to find favor in your motion. They might just dismiss it, and then you're out the $100. If you are in a situation where you are unemployed, like I was at the time, or you are hurt, or for any reason you're on DHS or any type of supplemental state aid, what you can do is you can file what's called an MC-20. And you can look this up. This is for the state of Michigan. I believe that there's probably one for every state. But what it is it's a fee waiver. And so you put on there your case number, and they waive your fees. And this has been extremely important. It's so important to tell you the fact that I have filed 99 motions on my docket, which is only since 2019. And I've not had to pay for those because of that MC-20. It has been such a lifesaver. Granted, at the same time, and it's almost eye-opening, the plaintiff, the mother, has filed 0 motions. That's even when she was at a period of where she had retained counsel. They have never filed a motion in this court case. So it just kind of sets the stage to understand, like, here I'm fighting this whole time, and the mother just sits back. the court defends her at every moment. That referee asking, oh, she's in school right now, so you don't ever use daycare? Like when she has a half day or when she has a day off, you don't use daycare? And the mom says, oh, yeah, I use daycare for that. Okay, well, we'll leave the daycare on the child support order. Wait, what? Are you the referee or are you her defense lawyer? Like, because this is just crazy. You just popped up with that and out of nowhere. Wouldn't
the mother have to prove that?
No, because they don't audit child support, so they don't make her show it. It's
whatever she says goes.
Basically, yes, it's insane. It is absolutely insane. Yes, and that's because of the original order that was set for that child support. Yeah, and then, it just, like I said, with her being in contemptuous action when we went this last week, that same referee, well, sir, you don't always pay the full $1,200 obligation of support every month. So why is it you want me to hold her in contempt of court for her not showing up on Sunday? She showed up on Saturday. So to me, that referee is saying, well, sir, you may do their child support order, but you don't do it to 100%. So it's okay if she doesn't follow the visitation order. That's illegal. That like a father or a parent is not to not have custody or visitation time, regardless of the support, regardless of any type of arrears. Those are two completely separate matters of the court. And yet here this referee is making light of the situation. I couldn't believe it. I mean, there's a grievance to be followed up, but I have one more court date before that where it's actually the show cause for the arrears. So I didn't want to file any type of action against her and have her be upset before I go in front of her here soon. But the grievance is definitely coming. I mean, this is not the first time that I've seen this in this court. I mean, there's been all kinds of tricks played. I was in the shower at 6:00 one day, right? And my wife came in and she said, oh my God, you need to get out of the shower. You're going to jail. I said, what do you mean I'm going to jail? She goes, look, they moved your court date forward. You were supposed to have court at 8:30 this morning. Well, apparently you can adjourn a court date forward as well as backwards. And I said, well, what am I supposed to do? It's like 6:00 at night. The court's closed. Well, when I called them, they tried to tell me that I had a bench warrant and this and that. And I said, no, I don't think so. Like, I called the post office. I saw when the letter was delivered. I went in and I had to prove it to the court. It was crazy, but they were trying to throw me in jail for misaligning their scheduled date with when the mail would even come. They didn't give me a due process notice. It was crazy. I mean, this is not the first time. I mean, I told you about the cops when they tried to arrest me there. Now it's just been over and over again. I mean, they forfeited my bond one time when I had a bond, when they did come in and they arrested me back in October, I think of 21. They showed up to my house without a warrant. I say without a warrant because the next day the warrant was signed. My wife met them in the driveway and they said, what are you doing here? Oh, we're here to arrest your husband. She said, well, show me the paperwork. We're not showing it to you. And I've got this on camera, but all of it, the entire thing. They told her, you can do this the easy way or you can do this the hard way. And they entered my house anyway. I have the whole thing on camera. One of the officers who was in the backyard said, oh, guys, she gave you access? They said, oh, kind of, something like that. And then beat me up, George Floyd style, had their knee on my neck. They were beating me against the wall. My wife tried to intervene and said, stop, you're going to kill him. And they pushed her with my infant son in her arms. And then I said, you guys realize you're on camera? And they picked me up and walked me out of the house. Now, unfortunately, in that part of the house, I don't have an actual camera right over it. But in every other part, had they been like 2 or 3 feet the other way, the whole thing would have been on camera. But it's just all these things together have been just terrible. But I know that at the end of this journey, when I finally have my daughter and she's back, like it's going to be so great. I'm so tired of it. I'm tired of this referee telling me there's history in this case. There's no history. There's not. She could try to use the termination of my son, who my son wasn't even involved. In all transparency, it was alleged that I discharged my firearm inside of my house, and they said that my son was there. None of that ever actually even happened. Like I said, I was a firefighter. I went to the county computers and checked. There was no 911 call. I went to the neighbors. I said, did you hear something? Allegedly, this happened at 1:00 in the morning. None of the neighbors heard anything. So how is it possible that a firearm could be discharged and that happened? Well, it was her story against mine. And again, in that situation, prior to me practicing and trying to study law as much as I can, I was told by my lawyer, if you sign this and you do 1 year and you take this plea deal, it's going to be the fastest way you can see your son. As soon as I got out, it terminated my rights anyway. It didn't even matter. But either way, I was facing 25 years and I did 1 year, and it was hard. It was a really hard time. I cannot wait till I see my son. He has the same name as me, so my surname is the third. He's the fourth, and I cannot wait to see him. I pray for it every single day. But going through these things are things that no father should have to experience. And unfortunately, I have. So I just love to share every piece of information I can to try to help out the next one. We really are the idols they look up to, and we offer them the best guidance that they're going to get. But you've got to watch out for these schools. You've got to watch out for doctors. Like, you are your best advocate, but only if you know what you're doing. So it's very important to practice.
Let me ask you a few follow-ups, if you don't mind.
Of course.
You mentioned earlier the knowledge of your daughter's injuries, and then you said something about not knowing her orthopedist, or it being difficult to find her orthopedist. Your daughter would have to have a primary physician.
Yeah.
So that primary physician would know the orthopedist.
Yes. So I've actually had to kind of fight with them a little bit using the MCL, and those records are being transferred now in the mail, all on a DVD. So I had to tell them I was going to FOIA. They finally gave in and said, okay, we don't want the records request. We're going to get it sent to you. Then they sent me a schedule saying how much it was going to be for the paperwork. And it got to the point of where I was talking to that manager so much that they're now releasing it. So I am hoping that it is going to be on there, because a lot of this stuff doesn't seem like it's actually, excuse me, good Lord, is being reported because the mother won't take her in. So there's been instances where I was told by email when we were in the parenting time place that my daughter wouldn't show up because she was sick. This was like a Thursday. So she was too sick on Thursday to make it to a Saturday. And then I noticed that she missed 2 more days of school on Tuesday. But when I reached out, was she taken into urgent care or a doctor? She said no. So I'm wondering, like, how much medical neglect is really going on here? 2 broken bones. The first time, I didn't even mention this part. So when she fell and broke the bone in her wrist on Good Friday, again, I saw her that morning of Good Friday. She went home, and the next evening on Saturday is when she returned. Within less than 15 minutes, she was complaining about pain in her wrist. To the point of after 15 minutes, she said, Dad, I have to go. I said, do you want to just go, like, because you don't want to hang out, or are you in pain? Because you've mentioned your wrist a couple of times. I'm in a lot of pain. I need to go to a doctor. Now, obviously, she didn't say it exactly like that, but essentially, that's exactly what she was telling me, right? And I'm like, well, let me take a look at it. And I could see it was completely swollen. So I told the monitor, I said, she's got to go. But I'm letting her go under the assumption that she's going to be taken to a doctor, because you guys won't let me do it. You've got me here in this facility. And it was very strange that day, because the monitor had walked her out. She tried to wave to the mom through the door, at the front door. She didn't come. So she ended up walking her all the way out to the vehicle. And when the monitor came back in, she said that the mom knew about it, that the mom said she was just being dramatic. And she's actually said all this stuff in the hearing as well. And then she had mentioned to me that my daughter wasn't in a car seat. Well, after I had called Child Protective Services in that situation, she recanted her whole story to say, no, the mom didn't say she was dramatic. That never happened, even though the mother later said it in the court hearing. Oh, there was a car seat in there. I wouldn't have said that. That's not something I would have said. But none of this stuff was being reported by that facility. So what was the point of paying $60 an hour? You know, I have my issues with them. I mean, it is what it is. But yeah, it's been a wild ride. It really has.
Let me ask you this too. Again, very superficially, but I think this matters. What percentage of all of these people that you've been dealing with are women?
A lot, actually. I've noticed that, and I am a bit of a talker myself. Obviously, you can kind of tell. But I've noticed also, not only are they women, but when I get to talking to them, they will mention a divorce or being remarried. So
I'm going to ask you. I know.
Yeah.
Trust me. I fully get it. I'm going to ask you another superficial question. Are they fat and ugly?
They're not desirable. They're not. Yeah, they're not at all. Yeah, Oh man,
this is the system.
Crazy.
I'm telling you, this is the system. You talk about social workers. You talk about CPS.
Yes.
You talk about school teachers. As God is my witness, like if you're a well put together man who's articulate and knows exactly what he's after, they can't stand you.
Yes, and the men that I've come to encounter are either without a wedding ring, or so they'll say that they're married or something, but they're clearly not showing anything. And I mean, I know that's more of a social standard, having a wedding ring. There's nothing biblical saying that you should, or they're gay. And it just seems like to me, and it may be opinionated, but those people tend to align with like a more of a feminist movement. Like they're against the straight cis male. I think that's the new term, is cis male now, being a straight hetero male. And they're against that. They automatically assume you're some sort of MAGA fan or something, and we've got to go against what you guys are doing. We have to disrupt the nuclear family and blow them apart. And it's just crazy the way that it's gone. I mean, I wish more than anything that things would go back to where the mom would be stay at home and my wife could be here and we could live off one income, but they don't. They've done everything they can to destroy our families. It takes two people now to even run one household, which, then it stretches you guys out. It limits you. You're not going to both be able to be involved in everything. And it's just so sad. It's very shameful in the direction that things have gone.
So regarding the school then, you are still requesting that documentation, or have they provided the documentation to you?
They've only provided one, and it was the most recent occurrence. It was that doctor's note where it says that the doctor had excused them for 3 days. And it was interesting because I was telling my aunt about it earlier today, and she's like, well, 3 days, that's kind of almost a week. I said, no, you don't understand. I said she missed Thursday and Friday of the end of the week. Then she missed Saturday, Sunday, and was out of school Monday and Tuesday. That's well over a week. All the way to Wednesday, I'm sorry. Missed all the way up to Wednesday. So she missed 7 days of school. She didn't miss 3 days of school. So how does that doctor's note cover those full 7 days? I mean, I can understand if the mother's in their ear saying, well, they're just still sick. They just still don't feel good. They need rest or whatever. And the school's saying, yeah, okay, that makes sense. But what if really something's going on, that she's being neglected and not being brought into the school for them to see? Not that I think that the school would report it, because although they're mandated reporters, they're just simply not doing it. So it's just a lot of concerns that I see going on. And I know I'm not the only person. So for me to believe that would be completely unjust, but this is happening to many, many people out there. I can guarantee it. The way that they were very orchestrated in the things that they were saying. But yet when I was on the phone with the principal and she's asking her coworker, how do I get into this? How do I do this? Oh, that's right. Okay. Yeah. I got to do it like this. Like, you're supposed to be the main person and you don't know how to do it. I'm asking you for these requests for these medical notes, and you're telling me they're at one of your constituents' desks. That's not a constituent. That's another staff member. And you're telling me you, as the principal, don't have access to that information? None of that adds up. You guys are transferring me to your school liaison officer who says, at first, yeah, I guess I kind of assumed that title as the truancy officer until I tell him the situation. He goes, no, that's far above my pay grade. That would be actually the principal, or it would be the administrator, Craig something. I don't have his name in front of me, but he's pointing the blame in the opposite direction. The principal, once I get her back on the phone and I ask her, she's like, oh, 2 half days make a whole. That kind of adds up, right? Not the way you're doing the math, not with 20 minutes being late, being a half day. That's 2 full days of school. I'm sorry.
Yeah. You're certainly getting the runaround. And not just from the school, but of course everybody. Let me ask you this, and again, it falls into the trust category, specifically again regarding your daughter's mother. And again, it's none of my business, so you don't have to answer it. But are you aware of the harm that the COVID shots are doing to people?
Absolutely.
Okay. I don't know where your daughter sits on that scale. I don't know where your daughter's mother sits on that scale. But just a piece of advice, you're going to want to keep your daughter as far away from that as humanly possible.
Absolutely. So none of my family here in my home. I have 2 children with my wife now, which is eye-opening, right? I'm still fighting for my daughter. Well, at the same time, so much time has gone on that I've been able to be married and have 2 more children, as well as my stepdaughter that I acquired. So 3 children in the home all the time. None of us have been vaccinated. None of us have, oddly enough, ever even caught COVID. But even if we had, we would not get it. The question is not asked, but I don't know the status of whether or not my daughter was. I'm assuming because the mother tries to propose that she uses a lot of homeopathic remedies on her and her children is what she's said in emails, that she's not gone and sought out that COVID shot, as well as their whole household had influenza A this last year. So I'm assuming they didn't get the flu shot, but I don't know. They could, because I hear a lot of, flu shot included. You get the flu shot and you're definitely getting the flu that year. I've heard stories the opposite as well, but I don't trust those things. We watched a movie, What the Health, 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 What the Health. And we were so shocked at the things that we were seeing in a bit of the food industry, but as well as the vaccine industry there. And a lot of people that I've came in contact with and talked to say, well, I don't take the vaccines. I don't take anything other than unless I really, really have to. Well, a lot of people don't realize is that in the food industries and the vaccine industries is how they're so symbiotic that 80% of vaccines actually go into the meat industry. So here you may do your best due diligence to remain away from these vaccines and medications, but if you're eating that meat from that Kroger or that Costco or any of those big block chains and not getting it directly from a butcher who says that he's not using antibiotics, animals, or free grazed animals, there's a possibility you're getting a vaccine in it. And we've seen a lot of research lately. They're going to start putting them into the food, like plant-wise as well. After watching What the Health, we actually stepped away from eating meat entirely. So it's been years, and I'll admit I cheat sometimes because how can you not have a sirloin once in a while? But we do try to remain away from it, as well as those dyes. And I can absolutely testify that we ran a small little lab in our house, if you will, where we went 30 days without giving our children any dyes at all. And then we finally gave it to them, and they went nuts. I can't tell you that if you stop your child from eating dyes and then run the test the next day, it's going to have any effect. It's obvious to conclude that you've got to give a little time for it to get out of your body. And I'm not saying I recommend everyone to do this either, but I am telling you, without a doubt, they had that dye and they went crazy. My son, actually, last night, I sometimes, like I said, I cheat, right? So I went to my dad's and he had a Faygo Red Pop, and I grew up with it. I love it. And so I had one. I don't have it a lot, but I had it. And my son says, I want to try it. He went absolutely nuts last night. I gave him one little sip, literally one sip out of the bottle. And he had fallen asleep, and I carried him into the bed, and he started kicking and screaming, and he didn't know where he was, and I just loved on him, and I had compassion for him. I figured it was because he was, waking up, but at the same time, I knew I had given him that one sip. And after about 10, 15 minutes of him going crazy, we finally got him to cool down. And he was right back to kissing me, saying, "Daddy, you're my best friend." And that's just something that him and I say probably because we're both boys. My wife tries to say he's your favorite, but he went back to what his normal self is. Like, he's the most loving, caring little boy, but he was literally violently hitting and kicking, and it was out of nowhere. Like, it was completely out of character for him. And I have to absolutely believe it's because of the dyes. And I did myself an injustice by giving him that sip, absolutely, and an injustice to him as well. But yeah, I absolutely agree with you. Stay away from those vaccines. I mean, I knew that from the start. I told my wife, I said, this is, it takes years to figure out what can be the after effects of a vaccine or any type of medication. And they just simply rolled it out too quickly. So I already was apprehensive to taking it. But I said, you watch, something is going to come out. And now look what we've seen. Women that are having issues, having children, these aneurysms popping up inside people's brains and in their heads, tumors and blood clots. Now we're seeing turbo cancers. Like, this is absolutely insane. And then you find out the doctors that are involved, like Dr. Fauci. And then, this is the first time maybe he made a mistake. No, he was involved in the AIDS epidemic as well. I'm a big proponent for not trusting the government. I really am. I mean, with the things that we've seen, the Tuskegee experiments, the HIV experiments, like different things that have gone on that are not talked about. What about the fog when they used that in Seattle near the bridge and all those people became infected and nobody even knew about it? Not the CIA, not the FBI, but one person who was sanctioned by the U.S. government to allow that experiment to happen. What about Operation Paperclip, where we took these Nazi people into custody, but they were doctors and they were so much of an asset that they couldn't just exterminate them for their war crimes that they did. So they implemented them into our system. And we're supposed to believe that there's still not experiments going on the people here today. Oh, but you would assume they'd be transparent. Well, how could they be? What would happen if the people knew they were being experimented upon? But yet we're conspiracy theorists to believe that as these conspiracies that we look into come true. It doesn't make any sense. Again, I just go back to, you have to be your own advocate. You have to study. You cannot be spoon-fed anything. Nobody calling your phone saying, I'm calling you about your extended warranty, has your best interest in mind. So if you do believe that, and that these telemarketers and scam callers don't have your best interest in mind, then why do you believe that the news is going to feed you what you need to know? They're going to feed you the narrative that they want for you to know and expect you to believe it. And if you don't believe it, you do believe it, because you can see in your mind that when you contest something with one of your peers or people that you work with, and they're so up in arms ready to fight over what you're saying, then you can see that there's an issue. You're telling me you're going to fight me because of something that you heard on the news and you believe it to be true, but you've done absolutely no research. You cite nothing. You go on Reddit and you see these people going back and forth. They cite no information to conclude what they're saying. And it's crazy. But the Bible tells us, leave a fool to their folly. Try to help them, try to guide them, try to be encouraging, and just do the best that you can. But sometimes you can lead a horse to water, but you can't make it drink. And it's unfortunate. But as these things uncover, as these things unfold, I think a lot of people are getting their eyes opened. And I hope that this current administration continues to do what it's doing. Don't believe everything that you're reading. They didn't ban Red Dye 40. They banned Red Dye 3. They're hoping to ban Red Dye 40 by the year of, I think it was 2027 or 2032. Well, why not do it now? What is it? It's because the lobbyists are going in and they're paying to have that stuff put in. Why do we care what color it is? What color our Skittle is going to be? Then we come out to find out. And I loved Skittles. Nitrous oxide is being put in there. What? This is crazy. We're getting food in the greatest country of the world that's illegal and banned in other countries. Yet we have systems and implementations, the FDA and such agencies like that are supposed to tell us that these things are not going to get to us at the end consumer. Yet they're still coming to us. Absolutely, I don't believe in the vaccines.
Yeah, well, first of all, the Operation Paperclip thing is another story for another time. But the two reasons I ask is because, of course, number one, it has everything directly to do with your daughter's mother and how much you trust that woman. That's the first thing. And the second thing, of course, is that, well, actually, it's three things. The second thing is you're going to want to find that information out regarding shot schedule or the amount of shots that she has taken. And you're going to want to find that out. Again, just a piece of advice. You're probably going to want to find that out on the down low. Certainly from a family doctor or any other way you can find that out. Certainly in an effort, hopefully, to discourage that from happening. The third reason is that the older she gets and the more she enters the school environment, certainly in the state of Michigan, they require them. Now, Here's the thing, and again, I don't know Michigan law on this, but I'm under the assumption right now that you don't have to be quote-unquote vaccinated with anything to attend a Michigan school, and that exemptions do exist.
Correct. Our children are on the waiver. Yes.
Okay, perfect. Then you're certainly going to want to do the same thing for your daughter.
Yes. With the intention to eventually have our children into homeschool anyway. But yes, while they're in the public school, that waiver is filled out for our children here. And as soon as I get that DVD with all the information, I'm hoping it will also show that vaccine schedule as well. Because yes, we've been wondering the same.
Gotcha. Okay. And again, I'm also running under the assumption that Michigan is one of these states that might be able to, quote unquote, vaccinate children in school without parental consent. That's something.
So I think that they were talking about that, but I believe that got shut down. I believe. I do know that Michigan is still one of the states, though, that does the gender, where if you go in and you're gender dysphoric, that they do not have to tell the parent, and they'll actually go as far as removing the child and making them essentially a ward of the state while they litigate the situation. I'm assuming they would impose a GAL, or a guardian ad litem, which is basically a lawyer with, again, allegedly your child's best interest in mind. But if this child is confused and they have those issues going on, they're probably going to try to walk that child down the path that they are saying. This is a minor child we're talking about. We're not talking about like an 18-year-old young teenager. We're talking about like early, ripe ages. Children start going to school at like 5-6 years old, sometimes even younger. And they're going to advocate for that child to make that decision for them. It just doesn't make sense to me. If you've got parental controls on your TV like I do, because we limit what we want for our children to ingest through their eyes, why would you allow them to make a decision like that? They can't go in and buy alcohol, but you'll allow them to make a decision like that. They can't use tobacco products, but we'll allow them to make decisions like that. Like, that just doesn't make sense. And I will tell you, my now 7-year-old, my stepdaughter, has come home and she's told me and my wife about a situation. I can't remember the specifics behind it, but we said, "Did you talk to the teacher?" And they said, "Yeah, they told me that it was handled and that I didn't need to go home and tell you, but I wanted to tell you anyway." But they are being told that they handle the situations there and you can leave your parents out of it, almost trying to build like a bond of trust, but trust against the parents, that you can confide in me as your teacher, you can confide in me as your counselor, and we'll handle the situation here. Don't worry about it. How important is your child? Because you're expecting for them to go to school and become educated, but what are they becoming educated on? Are they becoming educated on other things and then not being told to go home and tell you about it? We all know as parents, it's hard enough to get information. How was your day? What did you guys do? It was good. We didn't really do anything. And that's all you get from them. And now they're building this bond of trust between the teachers and counselors to tell you even less. That's an issue. That's very concerning and eye-opening to these things that are going on.
Communism.
Yeah, it is.
Yep.
It is. Yes. But why wouldn't they? If they infiltrate us at the youngest parts, the children, what are the children, in the biggest point of view? They're the next coming generations. I believe that was, I wish I could remember the exact book, but the Russian guy who said how to do all this stuff put that in there, saying go in and infiltrate the schools. Look at what we see. We see some of these very conservative children going into these large colleges and coming out a completely different person, hating their parents because of views and values that they grew up with. But now they say, you're just not understanding. I said in the beginning, you give a mouse a cookie, they're going to want more than that. And this all happened back when we started to allow gay marriage. And when gay marriage happened, they wanted it as a civil union. It's not right that we're together, a man and a man, and then the man dies and we can't be a beneficiary to this or to that. So they started to allow it. And now look what it's grown into. I don't hate anyone, and I'm very clear on that. But some things are indecent or morally corrupt, and they should not be put into the eyes of children. I, as a man, cannot. Everybody goes to the bathroom. Everybody goes to the bathroom. But I cannot, as a man, go out and pee behind a tree without catching a charge of indecent exposure. But yet a man can go down the street in a parade naked and indecent in front of children, and there's no crime that's committed. Make that make sense. That doesn't make any sense at all.
No, that's the state of affairs. Yeah. Let me ask you this then, too, just to kind of round things out here, certainly regarding you putting together a case of neglect, potentially, because it certainly seems like that's the direction you're heading in.
I'm trying. They don't want to substantiate, but that's what I'm trying to do, yeah.
Right. Well, let me sort of wrap up by reading this AI explanation of all of this. Again, just for anybody else listening, I think there's some pretty good advice here, and you've certainly given more than enough. There's no doubt about that. Your experience alone is perfect advice. Let me see here. So it says the following here. It says, document everything related to the suspected neglect. Courts don't act on suspicion alone. You need proof. This could be photos of unsafe living conditions, medical records showing untreated issues, school reports of absenteeism, or witness statements from people who've seen the mother's behavior firsthand. If Child Protective Services has been involved, get those records too. Be methodical. Vague claims like, quote, she's a bad mom, unquote, won't cut it. Specifics matter, dates, times, and incidents. It says file a custody complaint in the circuit court of the county where your daughter lives, or child. It says you can start with a complaint for custody, quote unquote, if there's no existing order or a motion to modify custody, quote unquote, if there is one. It says Michigan Legal Help, which I assume is a website, has DIY forms for unmarried parents that can guide you if you're going it alone, though a lawyer familiar with family law in your county could sharpen your case. It says at filing, request an emergency hearing if you think your daughter's in immediate danger. And then it says neglect that risks her health or safety might qualify. It says prepare for the best interests evaluation. It says the judge will weigh factors like your bond with your daughter, your capacity to care for her, housing, income, emotional support, etc., and the mother's fitness. Neglect could tip this. It says think failure to provide food, medical care, or supervision. If she's got a history of substance abuse or mental health issues affecting parenting, that's relevant too. But you'll also need to show you're a solid alternative, stable, involved, and willing to foster a relationship with the mother if it's safe. It goes on, it says expect the friend of the court or FOC to get involved. They'll investigate, so it says, interviewing you, the mother, maybe your daughter, and recommend custody and parenting time. It says be honest with them, but don't vent. Stick to the facts about your daughter's welfare. If neglect's clear, they might back you, though they often push joint custody unless one parent is seriously unfit. It says if it goes to a hearing, present your evidence cleanly. It says witnesses who've seen neglect, like teachers or neighbors, can testify. It says avoid mudslinging, focus on your daughter's needs. Michigan courts don't favor fathers or mothers by default, but they do lean toward keeping both parents involved unless there's a compelling reason not to, like proven neglect. And then again, it gives more practical tips like staying calm, and neglect can be tough to prove and things of that nature. Now, here's what I asked this later regarding documentation that the school has to provide. I said, what role does a school play in providing documentation to the parents of a child who attends that school specifically for legal purposes or custody battles? Here's what it said. It said a school's role in providing documentation to parents for legal purposes, like a custody battle, is generally to act as a neutral source of factual records about the child's education and well-being, not to take sides. Not sure that's the case in your case, but this is just what they say here. It says, in Michigan, or most places in the United States, schools have specific obligations and limitations shaped by state laws, federal regulations like FERPA, Family Educational Rights and Privacy Act, and their own policies. It says, here's how it typically breaks down. It says, under FERPA, parents with legal rights to their child, i.e. not stripped by a court order, can access their kids' education records, quote unquote. This includes attendance logs, grades, disciplinary reports, teacher notes, health records held by the school, and sometimes even observations about behavior or home life if they are documented. See, that right there is something too that you may want to try to obtain. Is any comment or email or memo or anything that a teacher has made regarding your daughter. So that could be something as simple as you just scheduling a parent conference with your daughter's teachers.
Yeah, which is one of the next things that I'm going to be doing. Actually, in this last week, I was talking to even the school bus driver to see who's doing these pickup drop-offs because she's being so late. And it sounds like it is the boyfriend of the mom. And so, yeah, I'm actually on a very current and active records request with that school. Once I have these, we're going to be on to the next thing and getting that. And to kind of coattail and swing back around to the first response from the AI, I absolutely agree with that. I've been told by many police officers and family court officials that I've known personally, not that I've been assigned to my case, keep a journal and a notebook. And I can't stress this enough. Write down dates and times. If you struggle with it, or you're, being overwhelmed in the situation of a custody transfer or something else, record it. Put your phone on your pocket and record it and go back later and jot it down. Say the time out loud so that it's in your pocket recording so you can go back and refer to it. Because again, and going back to what it was said, you can't mudsling. You can't just throw things out there. The burden of proof lies on them that bring the accusation, meaning you had better have concrete evidence. It tells you the best interest factors. There's 12. It's a little lengthy, but it's not so lengthy. And it helps you by, if you look it up, those 12 interest factors, and in Michigan, there's also another 9. But if you go through and you read those and you have it all filled out, it's going to go back to, again, the solidarity that it spoke to. You're going to be solid in your answer and reason as to why you should be the better custodial parent because you're following those best interest factors. In terms of Michigan Legal Help, that's an online resource, but it's also in the court. So they appear at the 1200 building on Telegraph every Wednesday. So if you go there, they can help you out. Now, they do have some stipulations, like if you've been accused of domestic violence, they may not help you. Or if you've ever been charged with a violent crime, they will not help you. So just keep that in mind. In terms of records requests from the Department of Health and Human Services, there is at least one location per every county. Now, you do not have to reside in the county that you're submitting the records request for, but I will tell you, bring a copy of your driver's license, a photo copy of it, so that if you go there to fill out the records request, you don't have to go back twice. Have that copy with it, staple it to the top. They'll have the records request there. You simply fill it out, put in the time and date for when you want those records requests for all children that are involved, all spouses or people living there, names included. It will break it down for you. But you drop it off, and within some time it's came. I've had to do it 2 times. I've probably got a total of about 3 or 4 inches worth of Child Protective Services documents. How they've not substantiated, I really don't know. But it's very important being solid on these evidence. You can't go in and just say something bad about the other parent. But if you've got concrete evidence, be it pictures, be it whatever, put it in your motion. Do not leave room open for an oral argument. Let the judge or the magistrate or whoever, if you're really in front of the magistrate, you want to get in front of the judge anyway, because that's an administrative law judge. They cannot do anything but propose orders or sanctions. Everything is proposed. A judge is the person you want to rule in your favor if it's a motion and you're trying to get the court to do movement. So put those things in there in your motion, but supplement them with evidence. Don't leave it open, and don't go to court unprepared. Have everything written down. Have it highlighted, the things that you absolutely want to bring up, because even if it's in your motion, they might just not ever talk about it and the court won't actually hear about it. So make sure you bring it up. Refer back to that front page of the motion. If there's multiple things that are contestable actions, that are contemptuous actions on that other party, make sure you bring it up and that it's sought after. I'm telling you, I've lost over 20 weeks worth of visits this last year. And each time I go, I ask for the makeup visits over and over again. I've never gotten them. But now that I'm finally on unsupervised, they gave me more unsupervised days than I was even officially going for in the first place to make up for that makeup time. So don't let that stuff go. Like, if you are a parent and you're passionate about your child, be passionate about your child. Don't be pacifistic in this way or passive with it and just allowing for them to step right through you, because they do not have your best interest in mind. I don't even believe that they have the child's best interest in mind. They will do whatever they have to do to get that family court issue quickly off the docket and back onto the shoplifter or whatever it is that they normally do. But you weigh 1% of their cases. They don't care about you. All you are is a fiscal incentive. And I hate to say that. I don't think anyone would have a situation where they would contest what I'm saying. But it's just very important. Be prepared and do your due diligence to study these things beforehand.
That's all awesome advice, no doubt. Let me mention this from a school standpoint, and I think this might benefit you greatly. Certainly when it comes to, again, scheduling a parent conference, or a teacher conference, rather. This is something that you're going to want to get out in front of before your daughter's mother does, in my opinion. One of the things that'll happen is again, you contact the school, of course, knowing the way that school apparently communicates with your daughter's mother is suspicious enough. But you may want to reach out to all of her individual teachers in a group email and just email them and say in a group email that I'm interested in having a conference. I'm interested in, finding out a great deal of information regarding, again, my daughter's academic status or behavior or this, that, or the other. There's a couple of things that are likely to happen in that back and forth. Teachers are very lazy by all accounts, okay? Sort of stereotypically so. And one of the things that sometimes happens is the business of scheduling a conference with teachers is done through counselors. My recommendation, given your scenario, and you're not asking for this advice, but I'm just giving it because I feel compelled here, is that you bypass the school counselor and any administrator in the building, that you contact the teachers specifically, like I said, in a group email. And when you do that, don't say anything about a custody battle. Don't say anything about potential neglect. Just make it academic and or behavioral, and that you're interested in, the schedule of the day and things of that nature. One of the things that they'll probably do as soon as they get that email from you is they'll take it to the counselor, and they may say, okay, this individual is claiming to be the father of this girl. Of course, she's in 6th grade, or she's 6 years old, right?
Yes, correct.
Okay,
so 1st grade.
So she has one teacher, probably.
Yes, one teacher.
Okay, so in that situation, depending on the teacher and depending on their personality, they may say, "Oh yes, absolutely, come on in," without even knowing who you are, or they'll take that request to the school counselor, who will then communicate with whomever they want, which is unfortunate, but they may reach out to the mother, they may reach out to anybody else and let them know what you're attempting to request. And then that communication will take place, and then eventually somebody would get back to you with a day and a time. Something else they might do, again, being lazy, is they might just say, "Your daughter is fine, everything is fine. There's nothing to, no need to have a conference. We're busy. We don't have the time right now, but your daughter, there's no need to meet because everything is fine."
Yeah, the dismissive short answer that they like to give.
Correct. That's likely to happen also. So I'm just running through possible scenarios here with you, just so that you can sort of have a heads up on all of this. But what you're going to want to do again, and say, for example, you find yourself in a classroom with your daughter's teacher, and there might be somebody else in the room. It's possible it would be a school counselor. It might even be one other person. So it might be, three people who work in the building and then you. But either way, what you're going to want to do is you're going to want to go in there again, not telling them anything about the mother out of the gate. Basically, again, they think that you're there for academic reasons or behavioral, or you're just trying to get to know the environment and the patterns and things like that. And then once you're done asking those questions and you get those answers, this is where you're going to want to chime in with whether or not they've made observations regarding your daughter's physical status, being, well kempt, showered, things of that nature. That's when you're going to want to start to get into those questions, because then you're showing concern for, of course, the well-being of your daughter. But at the same time, you're sort of, I would say, I don't know how to put this.
Putting them on notice.
Well, yeah, kind of. But you're being vague as to what your real motives might be. And then again, give them just a little bit. Give them an inch and they'll give you a mile. That kind of thing. So just let them talk and then see what they tell you, and then build off of that and see if there aren't more questions that come to your mind as a result of what they've already said. Again, you can ask about, like you said, the boot on your daughter's leg. Were you aware that she had to wear this boot? How often has she been wearing that boot? Things like that. So
yeah, which is actually one of the questions that I had asked the principal this last week was, like I was saying, with her telling me that she was in pain even recently, and telling me that she was having ongoing issues. Now she's 6, so she's not too specific. At that age level, they're not too specific with what's going on. But she told me she really hasn't been wearing the boot, and it's because she doesn't want to. So when I reached out to the school, I said, you as the principal may not know, but I would like to request that you speak to the teacher. And they came back with the answer that she has not been wearing it for quite some time. So once I get that osteo doctor's information, it's going to be very, eye-opening to me to at least find out what's going on, because as far as I know, she's supposed to be wearing it. But the 2 Saturdays that she's come over, she hasn't been wearing it.
See, even without the doctor documentation, you can still sort of pry into that issue specifically through the teacher.
Yes.
Right, which is,
absolutely.
Again, in my opinion, and my advice is to get out in front of that regarding their teacher and get to their teacher and question their teacher a little bit about some of this. Because, of course, then you can use that as evidence to back up your claim and your side of things, certainly in court.
Yes. And one of my friends, he was a church member of mine, and he's also one of the listeners to the Dangerous Info podcast. I reached out to him because he's a teacher, and some of his advice also was that sometimes teachers will write down notes, but they won't technically document it into the system for the rest of the staff. So by gaining access to that teacher, you may find out some information that they just kind of noted that was concerning at the time, but then they let it go as, whatever progress was made. But if you can get a hold of those notes, like you're saying, there may be something in there that's kind of strange, and I will say exactly like you were saying, with being unkempt, my daughter, she'll come and she's in like old hand-me-down clothes, whereas the mom is dressed up in the Lululemons and, looking like a mall mom. Like it's just crazy, So someone that's getting $3,800 a month in child support from 3 dads, you would think that the children would be well off, but that's not what that money's for. It's not what it's for. It's
Right.
for the moms, apparently. So,
Well, the other thing too, in a parent conference, and certainly it works this way in most cases, there will be a note taker. Someone will take notes, and it'll be more than just we met with the parent of so and so. Someone might even bring in a computer, and they'll actually literally be typing while you're talking, and they'll almost take dictation. That can be a bit overwhelming, but at the exact same time, that can also work against a school district and a teacher and a counselor and everybody else in the building, because if they're documenting things that they have not reported on previously, well, then they're in the wrong. So my recommendation is that you take some notes, and if you can, even though it might not be admissible in court, I would record them. Now, I don't know I don't know if you can record them legally with their permission. I don't know if you can say, look, I'm going to record this just for my own whatever. Do I have your permission to record? You might want to do that. And ask them. If they say no, then okay, I'm just gonna take notes then and just do it that way. But there has to be a record keeper usually in a conference. Certainly that's kind of the way that it works these days. At least it worked that way when I taught, and certainly toward the tail end. Because when it comes to, just a little note or a conversation between a couple of school employees, you're never going to get a hold of any of that. And they don't have any obligation really to tell you the truth about some conversation that they had about possibly witnessing neglect. They'll just downplay it or say that no conversation ever took place or no observation ever took place or whatever. But during an actual conference, there will probably be a note taker.
Yes. And in Michigan in general is a 2-party consent case. So as long as there's only 2 parties involved, you can record without the consent of the other party. If that note taker's there being the third person, yes, you would absolutely have to ask for it. You can say they're for your own notes, so you can refer back to it. Or even if they say no, you could still record it, but you'd have to be in knowledge to know that you're not going to be able to implement that into the court record, like you were saying. It may be beneficial for you to go back and say, well, we talked about this, and try to bind them to what they're saying, holding them responsible. But if it's just the 2 people, you should be able to actually bring that into court if need be. Now, if they're saying it, hopefully their notes will reflect the same. But yes, absolutely great advice.
Let me keep going with this AI answer because it kind of wraps up and it, I think, hits on a couple of other excellent points too. Again, everything that we've just discussed, it says for a father in a custody dispute, this stuff can be gold. It says, say if attendance records show the mother's neglecting to get the kid to school, if a teacher's note mentions that the child's showing up hungry or unkempt, both parents usually have equal access unless a custody order explicitly restricts one. It says to get these records, you'd make a formal request, usually in writing, to the school's principal or records office. It says FERPA doesn't set a hard deadline, but schools must respond promptly, often within a few weeks. Usually it's 30 days to 2 weeks, somewhere in there. It says some Michigan districts might have tighter rules. It says check the school's handbook or call the district office. They might charge a small fee for copies. Again, they can usually send you any documentation over a PDF over email. So don't let them talk you into
paper copies.
Right, exactly. You don't need hard copies.
Yeah, and also just to put in some advice there, make sure you CC someone. If you can CC another administrator, just to put it in their mailbox, even if they go without reply to your email thread, it goes in there to at least show that there's some sort of movement going on. And if you don't have their access or you're, with counsel, CC your counsel. Even if your counsel's not too actively involved in your case. Because I know that there's a lot of lawyers out there willing to take your money and not so much willing to submit a motion on your behalf. They'd rather kick the can down the road and prolong the issues. But if you're passionate and you're trying to do this, do your best due diligence by adding somebody else to the case. Even if it's a family member, like my aunt is very involved in my life, and I CC her on some actions just to show there's somebody else here looking at this. Whether or not they're replying or not doesn't matter, just so that they know. And if they reply to you without CCing, make sure you actively say, if you could please include all, hit that reply all when you're referring to me. I'd like to make sure that everybody is in this documentation.
Yeah, that's solid advice, no doubt. It goes on here, and it says, again, schools can also provide affidavits or testimony if subpoenaed. And this is, again, where the schools basically screw themselves if they don't know what they're doing, which many of them don't. It says, for example, if you need a teacher to confirm your daughter's been absent 20 days under the mother's care, you'd ask your lawyer or yourself, if pro se, to subpoena the teacher or attendance clerk. It says, schools don't volunteer this. They're reactive, not proactive. I love that the AI system says that, because I say that on the show all the time.
It's so true.
They always say they're proactive, and they're the exact opposite. Even the AI system has that figured out. It says they'll comply with a court order, but won't dig up dirt unprompted. It says, and they're cautious. FERPA penalties for mishandling records are steep, so they stick to what's official and documented. It said, if neglects the angle, specific records matter. Attendance is a big one. Michigan law flags kids as truant, quote unquote, after 10 unexcused absences. It says the schools track this. Health logs might show recurring untreated issues like lice or hunger tied to neglect. It says behavioral reports could hint at home instability, but schools won't speculate beyond what's recorded. So don't expect a teacher to write "mom's neglectful," quote unquote, unless there's hard evidence they've seen. It wraps up, it says limits exist. Schools won't release records if a court says you've lost parental rights, and they'll redact stuff about other kids, like if your daughter's in a fight with a classmate. They always do that, of course, in documentation. You know, they'll redact other kids' names, of course, because they're minors and they have to. Same thing with contact information and things like that. They say they also won't hand over personal teacher notes not kept in the official file. And they're not detectives. If neglect happens outside of their view, they won't investigate unless CPS loops them in. It says practically build a good rapport with the school staff. Teachers and counselors might not testify voluntarily, but they'll document what they've seen if you ask them to. Like if your daughter's showing up late or upset, get records early. Delays can stall your case. And if the school drags its feet, a lawyer can lean on FERPA or Michigan's Freedom of Information Act for public schools to speed things up. So it says, again, it just wraps up here. It says, in your situation, the school's a tool, not an ally. It says they'll give you raw data, dates, times, facts, and you can use that to show a judge that your daughter is better off with you. So there you go.
Yeah, and I'm glad that it says kind of like what I was saying, where my buddy Nate, the teacher, had said, you know, the teacher may put something down, but it might not be documented into that actual file for your child. And for those pro se people out there, which it means you're basically doing your own lawyer work. Your pro se is Latin for doing it yourself. The MC11 is your tool that you're looking for. That's the SCAO approved document, the form that goes to the court for a subpoena. That's an MC11. So you'll fill that out to the best that you can. Keep note, you do have to have that signed by a notary. Do not sign that document until you're in front of the notary, because some notaries will make you reprint it and start over because they have to validate that they're watching your signature. That's what their job is for. So it's not that they're upset with you. It's not that they don't like you. That is actual practices. They're supposed to watch that. But that's an MC11. That's to subpoena people. That's to subpoena forms. That's to subpoena documents. In my case, like I have to do it. The mom alleged she hasn't been working, but I she's using the same CPA she's always used. So they've got a subpoena coming to them. But you got to use these tools, and you got to know how to do them. If you mess up, read the case captions. If you're using MyFile, don't call MyFile, call the court clerk. The clerks are there. They can't give you legal advice, but they can tell you, hey, you're missing a case caption on this. Well, what's a case caption? Well, it's got to have your judge's name on there. It's got to have the court address. It's got to have your docket number, plaintiff, defendant's name. You got to make sure it's all filled out correctly. Don't get frustrated. Keep in mind that this is a learning experience. You're doing it for your child. You're trying to, unless you're wasting someone's time, including your own, you're really trying to do this for a reason. So if you're doing it for a reason, just know that before you could run, you had to learn how to walk. So learn this once you can. I hope that it's a benefit to you and you can share it to other people that are also going to gain benefit from it. But this is very worth learning how to do these things. And it's not just for school. It's not just for medical. This could be something that you have to do in the future for an elderly loved one when you have to reach out for that information about them as well. Because Child Protective Services, although it is called Child Protective Services, they also deal with the abuse and neglect of older people as well. So knowing this information is very beneficial for your life. Take interest in your life. Take interest in your own education and making sure that you can fulfill things to your best potential. The Lord tells us to do all things with the most of it because you're doing it for Him. You're doing it for His glory. In these situations, you're doing it for your own as well, your own being your children, your own being yourself, for the well-being of your family. And so it's very important, and I can't stress it enough. Take interest in these things. It's just so important to know. So again, I really appreciate this opportunity. I absolutely stand behind what you're doing. And just thank you.
Well, thank you, man. I appreciate it. And definitely stay in touch and keep me in the loop as to what's going on. I'm interested.
I absolutely will. I hopefully will be calling you back with a follow-up with some good news.
Sweet.
So we'll see where it all goes. But yes, I'm hoping parent-teacher conferences are coming up here soon. One last thing, if you get some of this information and you want to immediately run right out, sometimes it's best to take a pause and get a little bit more. You don't want to come with breadcrumbs, but maybe a piece of the slice of the bread that you've kind of reconstructed. You want to have enough that's going to have substance to it and weigh in before the court. If you come in with just one little thing, they had a bruise over here, they missed school over here one day, they've got to have consistency and a track record of the things that are going on. So that's why I've said, it's March now, towards the end, almost into April. I just got access to this stuff late January, but there's already a lot of movement. But not everything am I putting right in front of the court because I want to build a case, and it's important to do that. Have those 12 best interest factors filled out. Have your motives very clear with what you want to do. Put your stipulations in there if they were to find some sort of cause for the court to have to intervene. Put what you want in those sanctions, be it imprisonment, which I try not to ask for anyone to be imprisoned, but if it's going to be easier because the mother is not communicating or the other parent's not communicating, to just pick them up from the school and drop them off somewhere else so that you don't have to run into one another. Maybe it's for the best, but just think outside the box, have conversations with people that are aligned with you and have your best interest. Deny the time to the naysayers because they're just going to get you frustrated. But have these conversations with people. Talk to someone like Dr. Brooks here and figure out and facilitate a plan. Don't do anything while you're angry. Sit on it. Write those notes in that notebook. Again, I can't stress that enough. And then make movement on it. But don't be complacent. Don't be lazy, and keep the fire going.
Thank you for listening to American Education FM. Make sure and check out AmericanEducationFM.com for more information. Take care and God bless.